Now, quick overview of some of the 2019 law changes, and we're getting close to the end, but I wanted to touch on these changes. The recodification went in effect October 1, and again, I've provided you with a handout of the code sections, and then some of the most recent amendments that took effect July 1, okay? Extended right of redemption. So again, the previous right of redemption basically stated that a tenant had the right of redemption, one right of redemption every 12 calendar months, and they had to exercise it prior to the general return hearing in order for it to be effectuated. Now, the tenant still has one right of redemption every 12 months. However, they can exercise that right of redemption up to 2 days prior to the eviction. And they don't have to pay all amounts outstanding owed up to that date. They just have to pay the judgment amount. So, and they can exercise their right of redemption. Soon expiration of writs of possession, writs of eviction now, went in effect July 1. So previously you were allowed to exercise your right to judgment for possession for 12 calendar months from the date of the judgment. Now it's shortened to 6 months. And in the event that the tenant redeems, that judgment is no longer valid. So you would have to get a new judgment for possession. Renter's insurance disclosure. So if your lease agreement does not require tenants to obtain renter's insurance, your client's going to have to provide them with more information and documentation. So it's probably best that you have a disclosure in there that basically says your landlord requires your tenant to have renter's insurance. It makes it easier for them, but that's one of the new changes that went in effect. Tenants may recover attorney's fees. I've always operated on Ionis just because in jurisdictions I've been in, when a tenant prevails in a tenant's assertion, meaning the condition of the property is one that was uninhabitable or poor, and they brought the landlord to court, most jurisdictions I've practiced in have always awarded the tenant, if they're represented by counsel, their attorney's fees and costs. Now the code specifically states that, but most judges always operate under that onus. And in the context of the amount, I mean, it could be a couple $1,000s, depending on the severity of the problem with the property. And as I stated, the prior law stated that you can enter into a lease agreement without, or a tenancy could be created without a written lease agreement. The new law says that if there's a landlord has to offer a written lease agreement to a tenant. If they fail to do so, the default provisions are tenancy is 12 months, rent is paid in 12 equal installments at a fair market value. Late fees shall be paid only in the event that rent isn't paid after the fifth day, before the fifth day, and the landlord may collect a security deposit. This is not going to have much impact on most of your clients, because if they are retaining your services, they should probably be sophisticated enough to have at least a simple lease agreement in effect. But I have clients who don't have lease agreements.